SJC-13087, Commonwealth v. Eli Vigiani.
Okay, Attorney MacLean.
Good morning. May it please the court. Ian MacLean on behalf of the Commonwealth. First, I'd like to recognize the trial prosecutor in this case, Assistant District Attorney Michael Glennon, who was on brief in the case as well. Your Honors, this court should reverse the motion judge's rulings that General Law Chapter 233, Section 120, Paragraph 4th, creates a waivable privilege and that it applies in a motion to suppress setting. As with any question of statutory construction, the purpose is to effectuate the intent of the legislature. And where the plain language of the statute is clear and unambiguous, that's determinative as to the legislature's intent.
Counsel, at this point, does the Commonwealth concede that it's a rule of disqualification?
Yes, Your Honor. The Commonwealth does believe that it is a rule of disqualification. The parties agree that it is a rule of disqualification.
Okay, so let's begin from there. I know part of the basic bone of contention is whether or not the words against can be read in the ways that the Commonwealth is saying applies irrespective of whether the proposed testimony is for or against. It means all testimony. But I found the respondent's brief fairly compelling on this point. I know that you raised that there might be some issues that might come up on cross-examination and so forth that might underscore that the testimony could then ultimately be used against the child. But talk to me about that language and the way that it's been parsed out in both of your briefs, that the fair reading in this rule of disqualification is that it's got to be evidence that's going to be used against. And in this case, it's going to be evidence that's going to be in support of the juvenile. So talk to me about that, because why isn't the fair interpretation of that just what it sounds like?
Yes, Your Honor. The answer to that question is normally we do use the plain and ordinary meaning of the words when we're construing the statute. There's an exception to that anytime that a word has acquired a technical meaning, like a tax case, or it's acquired a specific meaning based on case law. This court's prior cases construing a statute. Here, that's the situation. This court in 1987 in Malay construed the second paragraph of this statute and determined that that word against referred not to the content of the testimony, the nature of the testimony, it did not refer to the content of the testimony, it referred to the nature of the proceeding we were talking about.
But it was a differently structured statute that was being talked about, right?
Same statute, yes, Your Honor, same statute, but a different sentence structure.
Right.
Not just that, Section 2 is a privilege, Paragraph 2 is a privilege.
Yes, Your
It's
Honor.
just a different, it's also a different concept.
It is a privilege within the same statute, but we're talking about the same word being used within the same statute. So there are cases that discuss when one word is given a meaning within a statute, it carries that same meaning throughout the statute. So let's talk about the form of paragraph 4th now, post-2018 amendment, and the form of paragraph 2018, the form of paragraph 4 pre-2018 amendment. So, and compare that to the second paragraph as it was construed in Malay. So in Malay, the court reached that conclusion about what against was modifying based on the phrase that immediately preceded against, and that was the list of the nature of the proceedings. Mm-hmm. So against modified that. And if you look at the form of paragraph 4th that existed pre-2018 amendment, they used the same structure. Against was preceded by the list of the types of proceedings that it was modifying. So when the legislature made the change in 2018, they modified the sentence structure. And you can see that because they added an entire additional category of persons. They added in parents shall not testify against their children. So because they added in that second entire category into that paragraph, they had to change the sentence structure. So that clause of the proceedings that against modifies moved from before against to after against.
So let's take our jurisprudence on statutory construction. Let's just concede for at least the beginning that there's some ambiguity, because you're arguing the same words that the respondent is going to say mean something different, okay? So now we go to the next layer of looking at the legislative history of this. Now, isn't the common sense view of the legislative history that we didn't want to do anything to undermine the parental-child relationship? Right? Do you at least concede that that was what they were intending to do, to not undermine that relationship?
Yes, Your Honor. And
so how would calling your parent in support of your decision, or in your position, the child's position, how would that be undermining the relationship between parent and child when the parent ostensibly would come in and give testimony that's helpful to the child?
So two responses to that, Your Honor. First is we're trying to discern the legislature's intent, and the clearest enunciation of that is the words that they chose to use. So if you look at the beginning of that fourth paragraph, they used the phrase "shall not testify." That's language of disqualification, not language of privilege. So that's clear. I think everyone would agree about that. So the legislature kicked off this paragraph by telling us this is a disqualification.
If we're going to read out the word against, I suppose.
Well, respectfully, I disagree with that, Your Honor, because the legislature was adopting the prior judicial construction of against, that what against modifies is not the content of the testimony, but the nature of the proceedings this applies to. The difference in where that list of the proceedings is because they added the second category of persons. So they had to move the list of the proceedings to after both categories of persons for the sentence structure to work still. Mm-hmm. And that did, yes, Your Honor, that did create a wrinkle. But if you look at the places where this disqualification applies, you can see that they're still effectuating that intent that we're discussing, which does not interfere with the parent-child relationship. Because they laid out two sort of categories where this disqualification applies. The first, at an inquest or a grand jury. So that's the process by which we're deciding if charges are going to be brought against this individual. So they're excluding the parents from testifying in that decision where we're determining whether charges will even be brought. And then the second place where they included this disqualification is in a trial, if that decision has been made. Now, as this court pointed out in In Re Grand Jury, the 2006 version, when they were interpreting that introductory phrase of "in the trial of," this court indicated that that phrase then modifies everything that comes after "in the trial of." We have the same construction here when they're listing out their nature of proceedings, where they list them as trial of an indictment or complaint or any other criminal delinquency or youthful offender proceeding. Same construction applies.
Different words, markedly different words.
Yes, Your Honor. It's
I mean, not even close different words.
Well, it's in a trial of and trial of an. It's the same concept as they're using that introductory portion of the phrase to tell you this trial of modifies everything that's coming after it.
Shall be compelled to testify in the trial of an indictment, complaint, or other criminal proceedings. That's section 2, right?
Correct, Your Honor.
Okay. Section 4. In proceedings before, first of all, it says, shall not testify against parent or minor child in a proceeding before an inquest, grand jury, trial, or indictment, or complaint, and then another or any other criminal proceeding. Right at the end, separated, or any other criminal proceedings. You can make your argument about 2 and 4, but the language is dramatically different. It's not even close.
Yes, Your Honor. The legislature did indicate that this disqualification applies in a series of settings. And so if we're talking about the phrase trial of an indictment or complaint, or any other criminal or delinquency or youthful offender proceeding.
Could you say to anybody other than a lawyer that testifying against doesn't mean that you don't have to testify against your kid? Could you, with a straight face, can you say that to anybody other than a lawyer? Because
yes, Your Honor, but this statute is aimed at lawyers and legal practitioners. It's about an evidentiary
because
concept.
we're lawyers and practitioners doesn't mean that we have to, give up our common sense of what against means.
Yes, Your Honor, the legislature could have drafted the statute more in a different or more artful manner. I may have drafted.
All they had to do is look at paragraph 1. I mean, neither husband nor wife shall testify as to a private conversation with the other. That's all they have to do. They could just say, neither parent nor child shall testify when either is a party. Not only is that not complicated, it's right in section 1, right there for them to read if they want to do it what you're saying.
Yes, Your Honor. They also could have broken out and added an additional paragraph to cover this new disqualification. The parent.
But if they want to come out the way you do, they just have to plagiarize themselves. in the same section.
Doesn't your approach raise all kinds of constitutional problems too? Particularly in this context. So the very purpose of having the parent there is to protect the child's rights, right? That's why we provide for this parental consultation. And I mean, essentially, this child is going to be left on their own if their parent can't testify, if there has been abuse by the police. Doesn't that raise all kinds of constitutional issues that we try to avoid?
So, Your Honor, the case that's presented here is limited to the motion to suppress hearing. And the Commonwealth's construction of the statute, which we think the plain language is.
No, I understand what you're saying, but you got to remember, this parent is there to protect that child's rights during the interview with the police, right? That's their very purpose of being there, because we don't think kids can stand up to cops by themselves, right?
Correct, Your Honor.
And you also have the right to produce evidence in your own behalf. So if the police are violating this child's rights, the parent is the one who's going to be the best able to present that case. You're taking away their ability to defend themselves in the motion to suppress with this. It just seems like there are constitutional issues that we want to avoid by treating this as a privilege, not a disqualification. And then if they waive the privilege, then you get to cross-examine them. They're acting at their own risk.
So respectfully, Your Honor, the Commonwealth's construction is that this disqualification does not apply to motion to suppress hearing. And that makes sense because the legislature was well aware of this court's body of law about interested adults.
Yeah, you have to win that argument, which is, we'll see if you win it or not.
Yes, Your Honor. But from our construction, it creates a coherent system that works so that the interested adult body of law still completely applies because there is no preclusion, no disqualification at the motion to suppress stage. So that child would be able to call the interested adult parent to testify on their behalf at the motion to suppress stage. Now, the legislature, as this court recognized, was going to be engaging in balancing competing interests. This court recognized that in Ray Grand Jury in 2000 when you invited them to craft a.
So I'm confused, though. So they can testify, but then at trial, they can't testify, right?
That was the legislature's decision.
And so when we're dealing with a voluntariness issue, right, we often have motions to suppress. We have the same issue crops up at trial under a voluntariness inquiry, right? So the parent can't describe the coercion of the child at that hearing, at trial, right? Under your view, they could testify at the motion to suppress, but if they lost it, the voluntariness issue, they're totally unable to testify.
Two responses, Your Honor. First, beyond the scope of the specific issue before the court here today. However, a statutory disqualification would yield to a constitutional claim. So a defendant would need to raise an issue and make that, we would suggest, the same sort of way in the spousal environment where they need to make a material and significant showing that it's necessary for them to present a defense, at which time the Constitution would trump the statutory disqualification and the child would be able to call the parent to testify at trial. So the legislature, in its wisdom, after this court invited it to do so in Ray Grand Jury in 2000, heard testimony and evidence, weighed the competing balancing interests. As this court indicated, they were in the group in the best position to do so, and they crafted a disqualification. And they crafted that disqualification to apply at two stages, the charging stage and the trial stage itself. They excluded the motion to suppress stage, so it creates no conflict.
Well, counsel, I'm confused by that, because isn't that a distinction without a difference? Because if you're saying that the parent can testify at the motion to suppress and gives this favorable testimony, and then you're saying by statute the parent would then be disqualified from testifying at trial, well, then wouldn't that bring it in within the hearsay exception? Because now you have the testimony was given at trial. They had the child and the Commonwealth would have the same opportunities to and have the same interests in eliciting the testimony back and forth. It would meet all of the bases to be introduced as prior recorded testimony, wouldn't it? At trial.
The Commonwealth would not be able to do so, Your Honor, because of the disqualification that the legislature crafted. We would not be able to use that testimony. The defendant could potentially call that parent if they made that preliminary showing. We would suggest that they would need to make that preliminary showing of material insignificance to their ability to present a defense. So our purpose here, Your Honor, is just to advocate for effectuating the legislature's intent. And we think the
Why
legislature.
why would that need to be shown? Why would the defendant need to show the constitutional need? Why couldn't the defendant just go under Justice George's exception to the hearsay rule?
Because the parent would be excluded under the statute, there's a statutory disqualification, so their testimony would be excluded, would be the Commonwealth's construction. So the Commonwealth would not be able to use that testimony from the motion to suppress hearing in its case against the juvenile or the child. However, the child could decide that they wanted to call the parent to the stand to testify, in which case, if they were able to hit those couple of wickets to justify that they needed this testimony to present their defense.
But why would they need to introduce those couple of wickets? Is that what you called it?
Yes, Your Honor. If they were able to satisfy that it was material and significant, would be the test that we would suggest, that they would need to establish to justify.
Where does that test come from?
It comes from the same concept in the spousal privilege realm. And again, it's beyond the scope of the case that's presented here before the court, but we do suggest that it still creates there is a workable system here by which the child would still be able to call their parent in their defense at trial. And again, our goal here is just, from the Commonwealth's perspective, just to effectuate the intent of the legislature. Which
Speaking of that, is there, did you agree with Justice George that this is ambiguous? That if indeed it's as you say it is, but looking at the plain meaning, it appears to be something else. Do you agree it's ambiguous or no?
No, Your Honor.
Not ambiguous?
The Commonwealth's perspective is that there is complicated but unambiguous language in both the introductory phrase that creates the disqualification and then the secondary phrase that establishes where the disqualification applies.
Okay, if you don't say it's ambiguous, that's fine. That's your position. Would it be fair for someone to say it's absurd then? Because if the point, has been pointed out, is to protect the child, and this would not be protecting the child, why wouldn't we say that couldn't possibly be right?
Respectfully, Your Honor, I would disagree with the characterization that as the legislature crafted the statute, it doesn't achieve that goal of protecting the parent-child relationship. It excludes the parent from testifying in the charging process, whether it be grand jury or inquest, and it excludes the parent from testifying adverse to the child's interests at trial.
Why is that protecting the child? Why is that protecting the child? If it's indeed something that would be helpful to the child?
We're now speculating, Your Honor. It's hard for me to guess as to what the legislature's thought process was, but the first thing that comes to mind here would be regarding their testimony at trial. Child calls mother, hoping that mother is going to testify to facts 1, 2, 3, 4, 5. Mother testifies only to facts 1, 2, 3. Child is then very upset with mother for not testifying to facts 4 and 5, which the child thought would be helpful.
Well, what about the opposite? So let's pose this hypothetical. The police are abusing the child. The police don't give him warnings. And the kid and the mom go, they didn't do that. Mom, you've got to come in and testify that they didn't do that to me. They're lying. And she goes, I can't do that. Is that's going to promote because of some legal distinction on the meaning of against based on the third clause of this thing, that's going to promote the parent-child relationship?
Respectfully, Your Honor, that from the Commonwealth's perspective, that was the legislature's decision. And we do recognize, however, that statutory disqualification could still yield to a child's decision that they needed that testimony to present their defense.
Okay,
There are no further questions?
thank you.
Thank you, Your Honor.
Okay, Attorney Menken.
Good morning, Michelle Menken on behalf of Eli Vigiani. May it please the court. At the outset, I've got to point out, in the Commonwealth's brief, it didn't really take a position as to whether this disqualification applied at the suppression hearing phase, and we've heard.
Can you just speak up a little bit for us?
Yes, I'll do my best.
Okay,
Can you hear me?
yes.
Okay, thanks. So the Commonwealth is now saying that this disqualification does not apply to the suppression hearing. So this suppression hearing giving rise to this appeal was to take place in January of 2020. The proceedings were stalled due to the Commonwealth's objection to the parent testifying at that proceeding. It's now almost a year and a half later, and evidently the Commonwealth is withdrawing its objection. There is no controversy before the court. In light of that, and in light of the expeditiousness with which juvenile court proceedings are meant to proceed, this court could dismiss this appeal and remand it to the juvenile court and let the matter proceed. However, the question presented in this appeal is really very simple. I disagree that there is ambiguity in the language about what testifying against means, just because the Commonwealth has taken a position that's contrary to the language of the statute doesn't make it ambiguous. I think that, as the justices have wisely pointed out, testifying against has a commonly understood meaning, and not only to the ordinary person, but also, and by the way, that's an important audience for criminal statutes or for evidentiary statutes. It's not just directed to lawyers, it is directed to ordinary folks so that they know what the law is. But even in the realm of decisional case law, to testify against someone is commonly understood to mean to take the stand as a witness for another party, or the adverse party. So there's no ambiguity there. This is
Does Millay create some ambiguity? I understand it's a different sentence, but I had trouble with Millay. So tell me how you reconcile Millay with this decision.
Okay, so it's a matter of commas, really.
I hate that because I'm never very good with commas, but go ahead.
It's tricky, and I think that's why sometimes, for example, in this instance, I'll urge that the lack of an Oxford comma doesn't mean that the legislature didn't intend to say what all of the other words together seem to say.
So read me the other sentence, the one that was interpreted in Millay. How was against used in Millay?
Sure. So, and if it's helpful to the court, I have printed out copies of the language. If anybody doesn't have it in front of them, I'm prepared to pass it up. But in second, the sentence is, neither husband nor wife shall be compelled to testify in the trial of an indictment, complaint, or other criminal proceeding against the other. And actually, in Millay, the question was whether against the other meant testify against. And what had happened was that the legislature had removed a comma in between proceeding and against. And the defendant in Millay was trying to say, well, they really meant to keep that comma, which would separate the word against and have it mean they shan't testify at these various proceedings in a manner that's against the other. That was what the appellant was urging. And Millay said, no, they took out that comma on purpose to make it consistent with what the law is, that the spouse can't testify in a proceeding where the proceeding is against the other. And I will say, Mr. MacLean was referring to the prior version of paragraph 4th, the child-parent exception, the 1986 version, actually included that comma after proceeding and before against. So it was not identical to the spousal privilege language at all. They put in that comma that Millay said would transform this from talking about the nature of the testimony to talking about the nature of the proceeding to talking about the nature of the testimony. And consistent with that, the original 1986 disqualification was uniformly described by this court's cases and the guide to evidence as a disqualification, that a child cannot testify against the parent.
Can we just pause for one moment there to put something aside? I agree with what you just said, and Section 2 for the privilege section says compelled, and Section 4 doesn't. But somehow, I don't know how or why, CPCS is saying this is a privilege?
Yes.
And you and the Commonwealth agree it's a disqualification.
That's correct. And I think that the concern, my understanding is that the concern that led to that construction was that it might be, if this is characterized as a disqualification, there might be some confusion about whether that meant that everything was disqualified versus just testimony against the child being disqualified. So I think that they sort of, because of the history of the case law, the judge in the court below also kind of had the same instinct, which was to say that if the child is permitted to testify on behalf of the child, that must be, we have to call that a privilege. And I would disagree. I would say that it's pretty clear that it's a disqualification by the language, and that we have to give that as narrow a meaning as possible, according to statutory canons and canons of construction.
I'm confused. What does that mean then? So you don't get, that you could put in the evidence, but they can't cross-examine on it?
Well, that's not our position, actually.
So
You can, the child, juvenile or defendant, can put the parent on as a witness
Right.
for the defense. And then they would be subject to cross-examination.
But only the good stuff comes in.
I couldn't hear you.
Only the good stuff comes in. That's the position, right?
Well, I think that there's always a risk that bad stuff is going to come in.
But that's the nature of a privilege, right? Once waived.
That's right. I mean, I would.
As opposed to a disqualification, which is where you're at.
I would urge the court that it would be appropriate for the juvenile court to limit the scope of cross-examination to what was broached on direct.
Boy, that's a big, huge change in our law of evidence all of a sudden. That
I
we don't have
understand.
wide open cross.
But this is all hypothetical because you're saying it's a disqualification.
It's all hypothetical. I'm sorry, I just couldn't hear the last part of your question.
Well, your position is it's a disqualification.
It's a disqualification, and I don't necessarily. So Mr. MacLean was talking about whether prior recorded testimony would be disqualified as well. And honestly, it's a tricky question, and it's not before the court. So I think it's best left for an occasion when certain circumstances have brought the issues into relief, and it's been fully briefed.
Can we also take something off the table that's not a tricky question? Everybody agrees that proceeding includes motions to suppress, at least now.
Yes, I mean, I think that Mr. MacLean's position was that it does not include motions to suppress, and I think that was based on his construction of the term against. But also, there was an argument in the Commonwealth's brief that perhaps, I'll just address the issue that the use of the commas again becomes really pivotal in seeing that the phrase trial of indictment or complaint stands alone and separate from other criminal proceeding, which is different than the parent-child,
Counsel,
than the spousal.
Could I follow up on Justice Gaziano's point? Because it's the part that concerns me about whether or not we construe this as a rule of disqualification. How is if it's not a rule of privilege, how does the trial judge then assess the credibility of witnesses?
Well, the witness is subject to cross-examination.
But if it were a rule of disqualification, when only, like Justice Gaziano said, wouldn't only the good stuff come in?
Well, our position is that all it means is that what can't happen is that the adverse party cannot call the parent as a witness.
Your interpretation is the common sense language, which is the Commonwealth can't call because it would be against the child. But once they decide to call, we don't throw the rest of the law of evidence out the window. Now they're on the stand. And the direct is finished, and then you have time for the cross. Your only request is that the cross be limited to the direct because of the implications.
That's what I'm getting at. Is that your position?
That is precisely our position.
Well, if you can't get into the stuff that's outside of that, again, there might be stuff outside of that that bears on the credibility of the witness testifying.
Well, I mean, credibility, I think, is always on the table. But I'm talking about other subject matters.
Sure, that's what I'm talking about. So, if in weighing whether or not the mother says that these protections weren't given to the child, and in weighing that, the Commonwealth wants to get into the fact that there have been instances in the past that, and reasons why the mom or the parent might shade the testimony that doesn't have directly to do with just this limited issue on the motion to suppress. Are you saying that the Commonwealth couldn't ask about those things?
No, I'm not taking that position.
Okay.
I would think that a witness's credibility is
Then I'm confused.
Right.
I don't understand the difference between your position and a privilege, because you're really converting the disqualification into a privilege.
The difference is actually important, which is that if it were a privilege not to testify against,
Right.
then if the juvenile were to call the parent would have the right to refuse to testify.
Right.
And where it's a disqualification, the parent does not have that right. The parent is subject to compulsion just as every other witness in every other situation, minus discrete privileges.
Your position, which I believe is consistent with what common sense against means, is that the parent, the would-be witness, has no privilege not to testify. They don't have the control over that. The witness, the juvenile, could say, well, parent, you're not being called by the other side, it's not testifying against me, so I want to call you. So the disqualification doesn't apply at all, and the parent doesn't have a privilege, so they have to take the stand. And that's completely consistent, is it not, with the legislative history and the back and forth between Senator Cream and Senator Tarr.
It is, and in addition, as far as the legislative history to that point, is that at least 2 prior drafts were introduced where there was still a discussion about whether it was going to be a privilege. So these drafts would have, cannot be compelled to. But those drafts also included, except if the parent has exculpatory evidence, then the child can compel the parent to testify. So clearly the legislature wanted the child to be able to compel the parent's testimony when it would be favorable to the defense in the discretion of the, after consultation with competent counsel, is this the potential value of this exculpatory enough that it's worth the risk of impeachment or prior recorded testimony or all of the normal things that you assess in deciding, for example, whether a defendant should waive the privilege against self-incrimination. So just one last effort at limiting the cross-examination. Speaking of, so when you waive a privilege against self-incrimination, for example, that's the same sort of manner that when it's cabined to the scope of direct in order not to trammel the privilege, I would urge that creating a similar limitation in this context would best serve the purpose of this legislation. And in addition, would best serve, the juvenile court has a mandate to keep the proceedings protective and in the best interest of the child. So in this particular context, it really is appropriate to place such a limitation on cross if the court is to reach that point. And I'll just say that my last point is that there's this question of whether the disqualification can yield to the constitutional right to present a defense. And I think that Mr. MacLean's construction of things has the court performing that analysis at many junctures. In his example, it was coming at the point about, is the prior recorded testimony admissible or not? And I think it's just cumbersome and
Well, it's not just cumbersome, as Justice Kafker pointed out, if we take your position, we don't have to worry about the compulsory process clause.
That's correct. That's
So
correct.
we avoid the constitutional issue by saying that against means testifying against.
That's correct.
Okay, thank you very much.
Thank
And,
you.
Attorney MacLean, I would just ask that if the Commonwealth's position is indeed that the statute doesn't apply for motions to suppress, I would like a 16L letter explaining why we should decide the case.
Understood, Your Honor.
Okay, great. Thank you.